All right. Welcome to everybody who's joined early. Thank you so much for joining me on this presentation today. My name is Sadan Mutsengi. I'm a labor consultant here at Legalese. I was going to give everybody else maybe a minute or two to come through and join, so we can kick off at exactly 12. So perhaps I can, in the meantime, just basically explain who we are for some of you who might not be familiar with Legalese. Legalese is a creative legal agency. We basically assist creatives as well as small business entrepreneurs with varying issues that relates to the law, commercial law, labor law, and so on and so forth. All right, I see it's 12 o'clock. We're supposed to start now, so we'll see what happens with everybody else can perhaps join us as we proceed. All right, so our topic for today, as most of you might be aware, is we're going to be discussing the differences between independent contractors and employees. And just to put name to face, that is the person who is right in front of your screens right now. And these are some of my team members that I work with here at Legalese. And this is what we're going to be basically looking at. Sorry if I'm a bit too fast, but I will just try and slow down. These are not the most important, but it's just aspects of what we're going to be dealing with today. But it's just an sort of like this is a table of contents of what we'll be dealing with today. The most important part is the overview. So I've got a little bit of a story to tell you. A few weeks ago, one of our clients contacted us and they wanted me to look into their employment contracts as well as independent contracts that they'd basically signed with their workers. And they wanted me to review these contracts and, give them a legal opinion. And long story short, it turned out that there was really no need to differentiate between the employees and independent contractors. And in essence, all the workers that were engaged by my client were all supposed to have been engaged as employees. Now, what are the consequences of actually mischaracterizing an employee as an independent contractor? Well, there are specific legal implications that are very important for each and every one of those two types of engagements that you can have with workers. So for employees, for example, they will be protected under various labor legislation in South Africa, whilst on the other side, independent contractors are not protected by the labor laws. So why focus particularly on this topic? Well, there has been quite a rapid growth in the gig economy, and this has also fast forwarded the focus, or rather the need to make use of independent contractor because of the flexibility of using independent contractors. You can always easily get skilled workers almost immediately when you have the need for them. And when you don't have the need for these skilled employees or skilled workers, you can easily dispense with them without having to deal with the myriad of processes that you would normally have to deal with when you're dealing with permanent employees, because South African law is quite, it jealously guards employees' rights. Now, we're going to look into how the law differentiates between employees and independent contractors. And the law does so by, firstly, what is called a Presumption Clause, which is in the Labor Relations Act. And this is I will explain a little bit more later what that is and what that means. And then on the other hand, we also have there are various tests that the courts have developed over the years. And these are the tests that the courts will use to determine who is an independent contractor and who is not. Moving on, what can employers do? We're going to also look at what employers can do to ensure that they do not mischaracterize employees as independent contractors. And then lastly, we're also going to look at the options that are available for employers who might have already mischaracterized employment contracts as independent contracts. All right. Now let's move on and let's start with the legal framework. So under the legal framework, it's very important for you as an employer to understand the legislation or regulations that apply to you with regards to the relationships that you engage with your workers. Either you engage them as independent contractors or you engage them as employees. Now, the Labor Relations Act 66 of 1995 is one of those most important legislations that governs relationships between employees and employers. It also sets out rights and duties that apply in an employment relationship. And then we also have the Basic Conditions of Employment Act. So this is the act that basically sets out the minimum terms and conditions that are applicable in an employment relationship. So if you do have an employee, but you have not put down a contract, you've not reduced your contract of employment with an employee into writing, these are the terms that will also just apply to that relationship. Okay. And then the last one is the Employment Equity Act. Well, basically the Employment Equity Act, its main objective is to redress some of the historical prejudices that might have taken place before because of our history here in South Africa. And those were not only limited to the politics of the country in the day, but they also found themselves in the employment space. So you will find that the employment equity also regulates issues such as discrimination and as well as the implementation of your BEE also comes from that. And you also realize that there are certain companies that do have employees who are employed as employment equity employees. Right. Now that we know what legislation applies to employees and employers, let's move on to the definition of an employee. It's quite important that we define the employee, and we'll also move on to define who an independent contractor is. Now, Section 213 of the Labor Relations Act defines an employee as any person, excluding an independent contractor, who works for another person or for the state and who receives or is entitled to receive remuneration. And any person who in any manner assists in carrying or conducting the business of an employer. Now, we need to emphasize here the fact that it has to be a person. So unfortunately, robots, you are not covered in terms of what, in terms of who is an employee. And it specifically excludes an independent contractor. So you'll find that the basic conditions, this definition in the Basic Conditions of Employment Act, in the Labor Relations Act, mirrors the same definition that is in the Basic Conditions of Employment Act as well. And just moving on as well, we've mentioned that it needs to be a person, the employee has to be a person, and this person has to work for the other person. And for that work, they must receive or must be entitled to receive remuneration. The second part of this definition is basically means that in any other way, that person can either assist or can assist the employer in carrying out or conducting the business of that person. right? Now, we know now that Section 213 of the Labor Relations Act defines who an employee is. But now, we now need to move on and find out, right, who is an independent contractor? Okay. Now, an independent contractor, unfortunately, the definition of an independent contractor is not found in any labor legislation that we have in South Africa. But generally, an independent contractor is someone who provides services for another person in a contract for work or a contract for services, right? So let's also look at then what that means. I'm just going to basically go through this with you briefly. There's a lot of things that come along with that, the definition of an employee, as well as the definition of an independent contractor. Obviously, I've mentioned that the Labor Relations Act and all the other labor legislation, they do apply to only people who fall within the definition of an employee, which means that if you're an independent contractor, unfortunately, the labor legislation does not apply to you, and you will not have any benefits under any of the provisions of labor legislation that we have. So if you can, for example, the employee, if you're an independent contractor, the only benefit, if you can call it a benefit, but in actual sense, it's actually a duty on an employer. And this is under the Occupational Health and Safety Act, where an employer is required to ensure the safety of their employees, as well as any other third party who may be performing any work or who may be dealing with that employer within their workspace. We've already mentioned that there's no definition of an independent contractor within any labor legislation. So it might seem quite easy that, okay, Section 213 explains to us, defines to us who an employee is. And at the same time, we know from that the general definition of independent contractor is a person who provides services for another person under a contract of service. So that you would expect that should set everything right. Well, unfortunately, if you look at our labor, if you look at cases that have come before the labor court, there's quite a lot of cases that have come before the labor court where there is no certainty as to a person who has been working for a particular company is actually an employee or an independent contractor, which obviously brings us to how then, the question that how then do you differentiate between an independent contractor and an employee within the legal framework? This takes us to Section 200A of the Labor Relations Act. And this is the presumption as to who an employee is. This is what we normally call the Presumption Clause, or the rebuttable, the rebuttable presumption. Now, we know that a person forms part of the organization. So before I go to that, I just want to mention this verbatim. What Section 200A specifically states is that until the contrary is proven, and any person who works for or renders to another person, who renders services to any other person, will be presumed, regardless of the form of the contract, to be an employee if any one or more of the following factors are present. So the first one is if the manner in which that person works is subject to the control or direction of that other person, then they'll be presumed to be an employee. If the person's hours are also subject to the control or direction of that other person, the presumption applies. If that person works for an organization and they form part of that organization, they will also, the presumption will also apply. And The fourth one, if the person has worked for an average of at least 40 hours per month over the last 3 months, the presumption will apply. And then the fifth one, if the person is economically dependent on the person who they work for, the presumption also applies in that respect. And then the sixth one, where an employer provides tools of trade to that person, they will be presumed to be an employee. And then the last one, if that person works only for that one person, then the presumption also kicks in. But it is important, as I mentioned earlier, that this is a presumption, it's a rebuttable presumption, which means that even if any one or more of these factors are proven by a person who's claiming to be an employee, the employer can then come through and say, well, be that as it may, I do have evidence to show that the person is actually not an employee. So that is where the rebuttable part of things come. It's an evidentiary tool. Section 200A is basically an evidentiary tool that allows someone who's claiming to be an employee to put those, to put forward some of these factors and bring sort of like a prima facie case to say that I am actually an employee. Because the principle in law is that he who alleges must prove. So if you allege that you're an employee, these are the things that you can prove, you can put forward to prove that you are an employee, and hence you will have a prima facie case. Now, as I mentioned, that is an evidentiary so the section is an evidentiary tool that can be used to prove that a person is an employee. But once that's done and the person now has proven a prima facie case that they're an employee, the onus of proof then shifts to the employer, who must then prove otherwise on a balance of probabilities that actually this person, although it looks like this person was an employee, he actually was not an employee. One of the cases that I can think of that sort of brings this to the fore, the practical application of the presumption clause, is one of the cases where a pastor was employed, or not employed, but he was engaged as a volunteer for one of these charismatic churches. And when the contract was terminated, he then claimed that he was an employee. And this is what the court had to say about this. And I like to quote this. The court basically said, if it looks like a duck, walks like a duck, and quacks like a duck, it probably is a duck. And so what this simply means is that the court used the presumption clause to come up with a value judgment and say, well, it actually looks like this person is an employee. Then that means, this person must actually be an employee. Now we move on to the question, now that we know how the presumption clause works, the next question is, does the presumption work, or does it apply to all employees in all circumstances? And this takes us to the next stage. And this is basically the next section of section 200A, subsection 2. Unfortunately, section 200A does not apply to employees who earn above the earnings threshold. The earnings threshold is has actually currently been changed or increased as of the 1st of March. And it used to be 205,000 Rand something. Now it's actually 211,596 Rand 30 cents per annum. So if an employee earns, a person who claims to be an employee is earning above 211,596, unfortunately, they will not be able to use the presumption clause. So now the question is, where does this leave these employees who earn over, or rather people who claim to be employees, but they earn over the earnings threshold. Well, this takes us to the tests that have been developed by the courts over the years in order to distinguish between an employee and an independent contractor. So the first two tests that were developed were the control test, where the courts only considered how much control an employer exerts on the employee. And that was considered to be the only test that is actually relevant when it comes to distinguishing between an employee and a contractor. And then that changed, and the courts developed the organization test, where the only consideration there was just how integrated is this person with the organization that they work for. So one example that I can give you is that if the person forms part of the organizational structure of an employer, during those times, they would actually be considered to be an employee. That being said, we now move on to the current test that is now being used as sort of like as a standard test to determine who an employee is as opposed to an independent contractor. And this is the dominant impression test. So the dominant impression test basically puts together or considers various indicators in order to determine the true nature of the relationship between parties. And that if you look at it closely, you'll find that it also encompasses certain aspects of the control test as well as the organization test. Now, let's look closer at the practical application of the dominant impression test. I know I did promise my director that I'm not going to give you guys a lecture on the law. I must apologize to him, and I also apologize to you, but welcome to Law 101, Labor Law 101. And I chose this, this case law because it sums up just what the dominant impression test is. And in this case, it basically just, if I can read it verbatim, it stated that the dominant impression test, it seems, entails that one should have regard to all those considerations or indicia which would contribute towards an indication whether the contract is one of service or a contract of work, and react to the impression one gets upon consideration of all such indicia. If you remember earlier, I did mention that the court, when they were using the presumption, the presumption test in the Labor Relations Act in Section 200A, the court mentioned that if it looks like a duck, it walks like a duck, it quacks like a duck, then it must be a duck. So what this means is that the dominant impression test, Section 200A, is actually, to a certain extent, a codification of the dominant impression test. The only difference is that it only applies to employees who earn below the earnings threshold. All right, end of the lecture. Let's move on now to what are these factors or indicators which form part of this dominant impression test that courts use to actually distinguish between an employee and an independent contractor. Now, these are the following. In fact, you don't have to prove all of these factors, or rather, an employee or a person who claims to be an employee does not need to prove all of these factors. They can prove one or more of these factors. And these are the following. Firstly is the right to supervision and control. I must admit, this resembles the control test. Remember, I did mention earlier that the dominant impression test actually encompassed some of the elements of the other tests that were developed by the courts before. And the second one is the extent of the employee's dependency on the employer in the performance of their duties. So in a typical employment relationship, the employer will always have the control over the work that an employee does, how they do it, and when they do it. So this is what is meant by the employee's dependency on the employer in the performance of their duties. Third one is in a form of a question, can an employee work for another? Now, a typical employment relationship, an employer can only work for one employee. An employee can only work for one employer. Fourth one, is the employee required to devote specific time to his work? In a typical employment relationship, yes, you have your 8 to 5, and these days you have people who work from 9 to 6 or whichever times that an employer can basically determine. And if you also remember, the Basic Conditions of Employment Act also talks about the regulation of working time. So as I mentioned earlier, the Basic Conditions of Employment Act only applies to employees. And this is just to show that if the worker is required to perform duties, to devote a specific time to his work, then that there is a pretty much clear indication that he might be an employee. And then on to the next one, is the worker required to perform duties personally? If in an employment relationship, yes. And then the other one, is the worker paid according to a fixed rate or by commission? In a typical employment relationship, the payment is fixed. But of course, I know this has become a bit blurred over the time, where employees can be paid at a fixed rate, and then the remuneration structure is such that they can then earn a commission over and above their fixed rate. But I will explain this a little bit later. And then the next one is, does the worker provide his own tools and equipment? In a typical employment relationship, the employee does not provide his own tools and equipment. It's actually the employer who does that. And then the last factor is, does the employer have the right to discipline the worker? In a typical employment relationship, yes. Now, I must mention that these elements these factors that I've just mentioned, which form part of the dominant impression test, they are not, they're actually open-ended in the sense that there are more other factors that the courts can take into account. And one example that I can give you is in a case where a property management company was basically taken to the CCMA by one of their contractors, who actually turned out to be an employee. And one of the considerations that the courts took into account was that the so-called contractor was actually required to ensure that he reports to the office and file certain records at the employer's office all the time. And that is what the courts actually considered and decided on that basis that the person was actually an employee. So this is not a closed list of considerations that the courts can take into account, but these are the main ones that the courts will take into account. If any one or more of these indications are there, they will form a dominant impression that the person is actually an employee. And then this takes us now to the re-characterization of independent contractors. Okay. What are we talking about when we talk about re-characterization of independent contractors as employees? So we're going to get into that shortly, but before I do that, I need to make sure that I let you understand what the legal consequences of the recharacterization are. And these include, for example, remember I mentioned that someone who claims to be an employee may go to the CCMA or the labor court as it may be, and claim that they are an employee. When they do become successful in that either CCMA referral or labor court case, that is when they are then recharacterized as an employee. It's actually a CCMA award or a labor court order that says, after we've listened to this person, whether they've been successful in using the presumption in section 200A, or they've been successful by using the dominant impression test, and they are successful, the court actually says, yes, this person is actually an employee. That is when, that is basically the recharacterization of, they would have been recharacterized by the courts or the CCMA from being an independent contractor to actually an employee. Now, I did mention before we started that there are certain consequences that apply to either an independent contractor relationship or an employment relationship. And one of those implications within an employment relationship is that a person will be entitled to certain benefits, annual leave benefits, paid annual leave benefits. The person will be entitled, if they earn less, or if they are within if they fall within the earnings threshold, they will be entitled to overtime. So once a court recharacterizes a person as an employee, as an employer, you will be liable for paying historical annual leave, historical overtime, and also certain other benefits that may have accrued to other employees within the same workspace. They can also, the recharacterized employee might also claim all those. And then also with regards to SARS, or payment of UIF, you may have to pay historical income tax. You may also have to pay historical UIF contributions. And obviously there are certain penalties that might apply in that regard. Then I must also mention that, and this is outside of the recharacterization of an employee within either the CCMA or the labor court. If it comes to, if for example, a labor inspector comes and finds out, maybe does an audit in your workplace, and they find that certain people are actually employees instead of being contractors, and this does not involve the underpayment of those people, you might be liable to fines from between 300 Rand to 1,500 Rand per person. But if the non-compliance does involve the underpayment of those employees, you might be liable to fines between 25% to 200% of the total amount, plus interest on the amount owing on the date of when the order is given. And this is within this process that is initiated under the auspices of the Labor Department. This is outside of the CCMA or Labor Court processes. Okay. Now we know just how dire a mischaracterization of an employee as a contractor can be. it brings us to the question, what can an employer do to actually structure a proper independent contractor relationship? So there are two steps that are basically apply in this instance. And the first one is you have to have a properly drafted independent contractor agreement. And as I normally do when I draft independent contractors for our independent contract agreement for our clients, I'm specifically insert a clause that states that the contractor is an independent contractor and not an employee, and that the parties don't intend to create an employer-employee relationship. Secondly, I also set another clause that specifically states that the contractor is free to control and organize his or her own manner of working and his or her working time. I also specifically mentioned that payment will be based on specified deliverables or results that would have been achieved. And then fourthly, you need to make sure that you insert a clause that says that the contractor is free to contract with and do work for other companies. So you are here dispensing with the control element of this relationship. You're relinquishing control. You're saying, I don't control this person, and this person is not confined to working in my space. They are free to earn their living elsewhere. Next, you need to also make sure that you insert a clause that says, well, not necessarily a clause but you need to ensure that in the entire independent contractor agreement, you need to ensure that you avoid any terms that are generally associated with an employment contract. So, for example, you don't want to mention anything about any benefits whatsoever. No leave. Don't mention anything about wages. Don't mention anything about leave, or anything that can be associated with an employment relationship you want to stay away from. And then lastly, you need to make sure that you put in a clause that talks about what happens if there's a breach of contract. The reason why I'm saying you need to put a clause that talks about a breach of contract is you don't normally, although an employment contract is a contract in the true sense of the nature, you don't normally put in clauses about a breach. Why? Because within an employment relationship, you do have certain processes, disciplinary processes that you can put into action if an employee is not acting within the confines of the employment agreement. And you definitely have to make sure that you state that the contractor will be liable for their own tax affairs. They will take care of their own tax affairs. Right. Let's go to, now that we know that, okay, this is how you structure an employment agreement on paper. I did mention there is also just another case that I want to let you know about, and this explains why this next step is very important. And it's the same case that I mentioned earlier on, which is Erasmus Property Development Company versus Mr. Mhlongo. I did mention that in that case, the court basically stated that Mr. Mhlongo was actually an employee. And this is despite the fact that the parties had actually concluded an independent contract agreement that specifically stated that Mr. Mhlongo was not an employee. So what does that mean? It means that the court is going to look beyond what parties put in writing, and they actually look at the reality of the relationship. So whilst it's very good and it's a good start for you to be able to make sure that you specifically state all these elements that I've mentioned in an employment, in a independent contractor agreement, it's very important that you follow that up with proper attention to the day-to-day management of that relationship to ensure that everything that if you say that I don't have, the person is free to conduct the their work, you cannot be seen then to be giving this person directions on how they're supposed to work, when they're supposed to work, and so on and so forth. So this has to do with the practicalities of this relationship. You have to make sure that you stick to what you say on paper. You need to actually practice it. All right. Now that we know what steps an employer needs to take to ensure that they structure a proper independent contractor relationship, let's move on to other interesting questions that may be related to this presentation that we have today. So you might have a question, and about employees who work remotely outside of South Africa, or rather, not employees, but workers who work remotely outside of South Africa. Well, when you're hiring a foreign employee and they're working in a foreign land, I would suggest that you engage those people as independent contractors, as the case may be. And this is based on my personal experience with some of our clients here. But what is absolutely crucial, if you do get into an independent contract agreement with somebody who works outside of South Africa, it is absolutely crucial that you put in a choice of law clause. And this is basically, is in respect of which law applies to the relationship that you are creating with this person. And I would suggest, if you're a South African employer or a South African principal, what you need to do is to make sure that you state that this relationship will be governed under South African law. Why? Because then you are in South Africa, and the assumption here is that you are able to contact either legalese or your lawyer, who might be quite conversant, in South African laws, and you can easily deal with any disputes that may arise out of that contract. Now, let's go to, let's say, what about your helper who comes to clean and do your laundry 3 times a week? Now, if we apply the presumption clause, your helper is most probably even though they do perform or the duties for other employers, they're most probably going to be characterized as a part-time employee because of elements such as control. You control what time they come in. You control exactly what they're supposed to do when they come in. And obviously, they're probably paid a fixed rate for the entire month, calculated on those 3 days that they come through. So it's most likely that your helper might be classified as a part-time employee. Then we move on to the third question, which is, are there any legal limitations to the use of independent contractors in South Africa? Currently, there aren't any legislative limitations to the use of independent contractors, outside of the fact that you need to ensure that if a person is engaged as an independent contractor, they should actually be an independent contractor. But otherwise, there is no limitation to the use of independent contractors. In fact, the rapid growth of the gig economy has seen quite a surge in the use of independent contractors because of the flexibility and COVID-19 happened, and this, for me, in my own experience, judging on how just difficult it was last year with employers having to now engage, or rather initiate Section 189 retrenchment processes, it just highlighted just how employment relationships are just can be difficult, especially for small business owners who want the agility of being able to take in skilled staff when the demand is high, and let go of them when the demand gets low, without having to deal with the red tape of labor legislation. And then we move on to the last question. How many times can an employer appoint an independent contractor? I think this is also, I've also answered this in part in question 3, where as long as the independent contract agreement is within the confines of the law, and it's not disguised as a independent, it's not employment that is disguised as an independent contract. You can use, an independent contractor as many times as you like. There is, of course, I must mention that traditionally, or rather, before, there used to be a notion that work that is done by an independent contractor is essentially ancillary to the core business of the employer. However, looking at what has been happening in practice, I think this notion has somewhat, fallen by the sideways, and people have been able to use independent contractors even for work that is related to their core business. We've come to the end of my presentation, and I'm going to open the floor for you guys to put in some questions. If you can see, I've just opened up a chat box. So I'm happy to receive some questions if you guys have some questions that you want me to answer. All right, we've got a question from Reese Shetty, and she's saying, what's the reason for the plus or minus 200K threshold? So from what I can tell, the 211 threshold is basically to distinguish between your low earners and your high earners. And labor law, South African labor law specifically protects those employees who are more vulnerable. And that's why you do have that 200,000 Rand threshold. I hope I've answered your question. And then we also have another question from Tony Seddington. And the question is, some independent contractors ask that we deduct tax for them. Can we and should we do that? Okay, so that's an absolute no-no, because an independent contractor should be able to, number one, they need to be registered for tax, either as a provisional taxpayer. I think most independent contractors are registered as provisional taxpayers, so they should be able to actually deduct tax for themselves. In fact, Schedule 4 of the Income Tax Act will explain this a little bit more, where they basically say that independent contractors are responsible for their tax affairs. And in fact, that is why when I draft independent contractors agreement, I specifically mention that the independent contractor will be responsible for their own tax affairs. Do we have any further questions? Oh, I see Reese has just replied. Thank you. All right, that's great. I hope I've answered your question, Tony. If you could maybe let me know in the message, or if you have a follow-up question. All right, great, thank you. Yeah, the floor is open. I'm happy to answer more of your questions. If you guys have more questions to ask. All right. Another question from Reese Chetty. Thank you very much. How do services like Sweep South or Uber work? So there's quite an interesting, I really haven't quite gotten a look at this judgment. And I think it was a constitutional court judgment in the UK that actually stated that Uber drivers can now be classified as workers. I need to have a look at that, because I know in recent years, Uber drivers here in South Africa have also tried to be classified as employees, especially the ones who actually work for the owners of the cars. So, you know, and then there's Sweep South as well. I've heard about this app where you actually, I think Sweep South, they are almost like a TES, a temporary employment service. Only difference is that they unlike the traditional temporary employment service providers, what they do is that they're using an app. So I'm not quite 100% sure how they work, but I think they should be working almost like a TES. They just place people, you know, with clients. I hope I've answered. I really don't have all the answers, unfortunately, for the Uber one. But safe to say that in South Africa, unfortunately, Uber drivers have not been classified as workers, and that is where it stops. I'm not sure if they've tried to go to the highest court in the land, because I know that this application was done. It should have been done either at the Labour Court or the High Court, but it has not been decided by the Constitutional Court. And then we've got a question from Tony Saddington. You'd like to know if you can get a copy of this presentation. Absolutely. We'll talk to one of my guys here at Legalese, Philip. He'll be able to get a copy of this presentation to you. And then Natalie Leach, thanks for the very informative session. Thank you so much, Natalie, appreciate it. Joanna Orr, COVID has got another question. Thank you, Joanna. COVID has meant downscaling. Can I bring in people I recently retrenched if and when I get busy again on a temporary basis? Can they become independent contractors if they only work for me a few weeks in a year? So, sorry about you know, having to go through the retrenchment process. It's not one of the best. Trust me, you can never. I've done plenty of those, and they're not, you know, they're quite draining, and I can imagine for the people who are actually involved. So one of the depending on the employer, I'll give you an example with one of our clients. So if you remember very well, when you go through the retrenchment process, the Section 189 notice will state, one of the things that you're supposed to state in that notice is how, if possible, you are able to assist the employees who may be affected by the retrenchments. So if you stated in your notice, in your either Section 189 notice or the retrenchment letters, how you could possibly assist these employees, you can certainly recharacterize them when you take them back. You can certainly have them sign independent contractor agreements, but you have to be absolutely clear on the on how you treat that relationship. So I think the danger in your case would be, because these people have worked for you before as employees, you need to absolutely cut that. You need to absolutely sever that the interaction with them has to be absolutely different. If it's possible, you need to make sure that they they know that they're managing their own time. You need to ensure that they know that they're now paying their own taxes. They need to also know that, you know, this, they only work for a particular period of time when the demand is high in your workspace. I hope I've answered your question, Johanna. If you have any follow-up question, you can go ahead and ask. I've got another question from Andrew Bros. Thank you so much for your question. Is there any risk in engaging student interns as an independent contractor? Okay, so ordinarily with student interns, I think that's a completely different, because you do have an intern sort of like employment relationship that already exists. You do get interns so that they can also get some experience in the workplace. But I don't, as far as I'm concerned, I don't think there's any bar to actually making sure that that intern agreement can be also converted into an independent contract agreement. But I'm not sure if that would be necessary, because usually interns, you only take them for a specific amount of time. And usually it's about 3 months or so. So I probably would not consider having them as independent contractors, because intern agreements usually are for a very short time. And, you know, they never really last for that long, and you shouldn't have any difficulty in dealing with them. And also, in terms of the benefits under the Basic Conditions of Employment Act and all the labor legislation, I think you shouldn't have much of a problem with interns. However, it's worth looking at the type of work that these students will be engaged in, and also the timelines within which you have them as interns, so that you can properly look and see if an internship agreement is better as opposed to an independent contract agreement. But ideally, you probably want to stick to an intern agreement. I hope I've answered your question there, Andrew. Natalie Leach, thank you for your question. Is there a difference between a service level agreement issued to a service provider and an independent contract? Okay, very good question. Thank you very much. So a service level agreement, with my limited commercial law knowledge, is usually between businesses, right? I'm not particularly sure if it can apply with individuals. But for me, I think there should be quite a significant amount of differences, because an independent contract agreement usually is between a specific individual who will have 1 or 2 other people that work for them, but they're not necessarily a business in the sense of parties who normally conclude SLAs. I hope I've answered your question there, Natalie. And then Francisca, thank you for your question. We have independent contracts who are outsourced to our clients to complete, for example, design work. However, our client provides them with laptops due to security protocols. Would they still be considered independent contractors, or they should they then be employees? Very good question, Francisca. So already in your question also has an answer already embedded in it, because you justify why the employers where your independent contractors are sourced would want to ensure that they basically use why they provide these independent contractors with laptops. So it is completely justified in this instance. Remember, that when in the presentation, I did mention that, for example, the presumption clause, or the factors within the presumption clause, or the factors under the dominant impression test are basically evidentiary tools. And remember, evidence can be rebutted. Evidence can be disproved. So in this instance, you've already, in your question already, you've already said that, look, for security protocols, and if they can reasonably justify that, they need to provide these laptops. And once the the workers leave, they leave. The tools will remain with the employer. Then we shouldn't have any problem in that respect. I hope I've answered your question, Francisca. Hi, Adam Armstrong. Thank you. Thank you for joining us, and thank you for the question. If a person's contract stated that they were an independent contractor, could the tests shown be sufficient to overturn that clause? Absolutely, absolutely, because the courts will look at the reality of the relationship, okay? They will look at the substance over the form, obviously the form being anyone. That's why, for example, in law, you are not, in the law of contract, you can't contract, the basis of your contract must be lawful, for example. So you can't have a contract that says, yeah, we agree that Adam Armstrong is going to hijack this person. So so it has to be lawful as well, first and foremost. I think I'm just going around in this one, but just to basically answer you straightforward, the courts will look at the reality of the relationship that you have outside of what you may have basically agreed on in a written agreement. Thank you so much. I hope I've answered your question, Adam. Thank you very much. Great presentation. Thank you very much. Reese Shetty has another question. Would scheduling regular briefing or update meetings count as controlling time for a team of independent contractors carrying out a creative project which requires a lot of oversight, for example? Okay, so when you schedule the meetings, the question that I would ask is, what are those? These are just regular update meetings. And you can, as I mentioned earlier, you can always rebut. So if those contractors come in and they say, look, our time is controlled because we have to come in and report. So that means that we are employees. As I mentioned earlier, there has to be a reason why you are scheduling these regular update meetings, right? It doesn't mean that you are actually controlling how these contractors work. You're basically saying, look, I'm available at this particular time, and I think I would appreciate if you can come through and let me know what is happening. I think context is everything, Reese. Context is absolutely everything. It might look like, okay, you are saying these people must come in every time, you're controlling their time. But like I said, as long as you can reasonably rebut this presumption that, oh, because you're controlling their time, their employees, then you should be safe. You need to be able to correctly justify whatever you are asking these people to do. So it's all about the real, as I mentioned earlier, it's about the real relationship that exists between you and those independent contractors. And you need to be able to also justify why you need to have those meetings at that particular time. So you can easily rebut that. As I mentioned, it's only one of those factors that may be taken into account. But if everything else shows that, no, these people, how they actually do their work, they control how they do their work and when they do it. And then at the same time, if you look at how these people are paid, they are paid as per the deliverables and all the other factors. If all the other factors show that this person is an independent contractor, even if you do control the meeting time, it may be seen that these people are actually an independent contractor. Remember, it has to do, the courts look at the dominant impression of all the factors that are present within your relationship. And the courts obviously will exercise a value judgment, and they will say, okay, on a balance of probabilities, does this look like an employment relationship, or is it actually an independent contractor relationship? So no one factor is more important than the others to determine whether a person is an independent contractor or an employee. Thank you for the question. I hope I've answered that. Joanna, okay, she's happy with the question, with the answer. Natalie's happy, Francisca's happy. Thank you very much. Reese Shetty, you've got another question. What about setting deadlines for deliverables? Does that count as controlling time? As I mentioned earlier, as long as all the other factors point to the fact that this person is an independent contractor, then you should be fine. Controlling deliverables, of course, if you have a certain deadline for you to be able, if you set certain deadlines, and remember, this is when you want this specific project, for example, to be completed. It's not you saying, therefore, I want you to work 8 hours a day. The contractor will look at the contract and say, oh, okay, from my experience, a project of this magnitude, I will need to work 5 hours a day or 12 hours a day. They determine how, as long as they determine how they do their work, as long as you pay them in terms of if they invoice you, for example, and as long as they are paying their own taxes and all the other important factors that point to an independent contractor relationship, if those factors are there, you should be fine. That cannot be, setting a deadline cannot be seen as you controlling the contractor's time. I hope I've answered that question. Francisca has got another question. Our contractors' hours are determined by the demand requested by our clients for a specific project. Would you consider this controlling their hours? Okay, let me read that again. Contractors' hours are determined by the demand requested by our clients for a specific project. Very good question, Francisca. So, as I mentioned earlier, the control of hours, it's quite a contentious issue, all right? You need to be absolutely clear that you don't control that person's hours. But if there is some amount of control, and this can be justified in one way or the other reasonably, and you do have other factors that show that, look, overall, this person is actually, despite the fact that your clients might control this certain aspect of how they conduct their duties. Remember, it also depends on, remember that the presumption in section 200A is but a presumption which can be rebutted, okay? And then also the dominant impression test is also another evidentiary tool. So what is important is that you need to balance all the other factors that are applicable in your case. And if it shows, if the dominant impression, for example, under the dominant impression test is that, yeah, this person is an employee, then that person will be considered to be an employee. So, like I said earlier, context is everything, and not one factor will be considered above all other factors. All right. And then Tony Saddington, many thanks for the presentation. You're welcome. Thank you so much for joining, Tony. Reese Shetty, very happy with your answers. Thank you. Thank you very much. Natalie Leach, I need to run. Thank you so much for joining. All right, looks like we are done with the questions. Thank you everybody for joining. Hope to see you in the next presentation. Thank you very much. Have a lovely day.